Please turn on microphones before speaking by pressing the button labeled push. Green light will illuminate. Please press the button again. Light will turn off after you have finished.
now call to order the Committee on House Administration's hearing regarding H.R. 186. It was introduced by the gentleman from North Carolina, Representative Walter Jones. The hearing record will remain open for 5 legislative days so that members may submit any materials that they wish to be included therein. And a quorum is present, so we can proceed. This hearing is for the committee to receive testimony on H.R. 186 from one of our colleagues in the U.S. House, the distinguished gentleman who represents North Carolina's 3rd Congressional District, Representative Walter Jones. And we are going to hear from Representative Jones on the necessity and the importance of this bill that he's introduced. And we certainly thank you for your attendance here today.
Thank you.
H.R. 186 is a bill to amend the Federal Election Campaign Act of 1971 in regards to who may distribute campaign funds for a candidate's federal election campaign. Under current federal law, only the campaign treasurer is authorized to disburse campaign funds, and that includes disbursing these funds in the event that the candidate should even pass away. Should Representative Jones' bill become law, it would allow candidates running for federal office the opportunity to designate an additional individual separate from the campaign treasurer who would be authorized to distribute campaign funds in the event of the death of the candidate. Essentially, this bill would provide candidates more flexibility when they are forming out their campaign for federal office and allow them the additional choice on who should have the responsibility over managing their campaign funds. When individuals donate to a candidate, they are also donating to specific beliefs and values. This bill that we're discussing today will ensure that should the candidate pass away, those same beliefs and values are carried forward. Of course, every candidate running for office hopes to hire a campaign treasurer who is not only capable, but someone who would know and respect our wishes should anything happen. Given today's cumbersome campaign regulatory environment, sometimes candidates must make a choice to hire an individual they might not know personally very well. H.R. 186 will provide a clear designation for those who should have responsibility over campaign funds should the unforeseen happen. And this bill will task the Federal Elections Commission, who is already responsible for receiving and registering such information filed by candidates, to update their forms and regulations. This is an important bill. It is also a nonpartisan bill. The House has also passed previous versions of this bill in every Congress since the 110th Congress. Not knowing a candidate's wishes on how campaign funds may not be the most common problem, but it could certainly be a problem, and it has precedence. And today we have an easy solution before us, again, that has bipartisan support. Again, I want to thank the witness for being here today, and would now like to recognize my ranking member, my colleague, Mr. Brady, for the purposes of an opening statement.
Yes, I would first like to thank Chairman Miller for holding this hearing, and thank my good friend from North Carolina, Walter Jones, for his tireless work promoting this bill. Currently, the Federal Election Commission Act offers no guidance on dispersing funds in the event of a candidate's death. H.R. 186 seeks to amend the Federal Election Campaign Act by allowing a candidate to designate an individual of his or her choosing to disperse campaign funds in the event of the candidate's death, and to provide specific instructions on how it should be done. Similar bills were passed in this House in the last 3 Congresses, and the Federal Election Commission stands ready to implement the bill should it become law. I have been a long-time supporter of this bill, and it is my hope that this common-sense proposal will pass into law. You know, as the Chairman said, when we usually first become members of Congress, it's like conventional wisdom that we would get a treasurer. It would probably, in my case, it was. It's no longer now, but it was that we would get maybe an attorney. No disrespect to attorneys, but I guess a little disrespect to them. Or an accountant that we think that would be a credible name that makes us kind of look more credible, especially running for election at times, running for re-election. And we've had many, many instances in the past where, quite recently, one organization did that for 4 or 5 House members, and for them to wake up one morning and find out that their funds were almost gone. And that major issue is there's no way to recoup it. Persons that were violated that trust, you know, were probably incarcerated, whatever, may be fined, but they would never could ever get their money back. So that happens when even candidates are alive. God forbid, God forbid, God forbid 3 times if a sitting congressman should pass away, and their money is entrusted to someone who they think would be looked upon as credible in the community where they run or in the establishment is a good thing. But that person, most of the time, does not really know the wishes of a congressperson, would not know. It would be up to them to do whatever they want, however they want, according to the guidelines and the law of how to disperse them funds. So it would only be logical, and it is logical and common sense bill, that we would have somebody that would be close to us, a family member, which a lot of us shy away from time to time, putting him as a treasurer because of the way he may look. But that person, a family member, would know best what the candidate, deceased congressperson, would want to have done with his remaining funds, what charities they would like, what other candidates they may be able to want to support, all according to law. So this is just a common sense bill. It kind of protects, and I thank Congressman Jones for your perseverance, your determination, and I feel your frustration from time to time because I know you have a personal story. And it just protects 435 here and another 100 over in the Senate side, that we can rest assured that whatever money we do have at the time of our passing would be distributed to the way we would want if we were here. And the only way to do that was to be able to implement this bill. Again, it's a common sense bill. It's the right thing to do. We hear too many horror stories out there. And we do work hard. And fundraising is a major pain in the neck for a lot of us. And we don't all like to do it, but we have to do it to be able to maintain who we are. And we do have the opportunity then to help other people and help other charities. So, again, it's just a common sense bill, and I applaud the congressman for, again, coming back up here, and hopefully we can get it done. And because it's such a good bill, when we send it over to the Senate, in their wisdom, they tack things onto it, you know, and that kind of weighs the bill down, and then it doesn't happen. So I will do the best that I can, and have had conversations with the Senate to try to make it as clean as it leaves here. Because we did not do that in the past. We let this bill go out clean. We didn't tack anything onto it. Hopefully, they won't do that, and I think that I'm totally confident that we could be able to pass it here and pass it there. And as we said, the Federal Election Commission is waiting for it to happen so they can implement it also. So, again, I thank the chairman for convening this hearing, and thank you for sticking with us again and trying to get this done. We passed it when I was the chairman. We passed it when I was the ranking member. I look forward to passing again when I'm the ranking member. So thank you, Madam Chairman.
I thank the gentleman very much. Is there any other comments from members? With that, I'd like to introduce our witness. Representative Walter Jones was first sworn into the U.S. House of Representatives in 1995 after serving 10 years as an elected member of the North Carolina General Assembly. Since entering office, he's been a strong voice for fighting for effective, common-sense government that returns power and control back to the people. His dedication and commitment to providing tax relief for American families, retirement security for our nation's seniors, a strong national defense, and a quality education for every child has earned him respect amongst his colleagues on both sides of the political aisle. He's been a leader in fighting the U.S. trade deficit, and leveling the trade playing field for American workers as well. Currently serving his 10th term, he's also a member of the House Committee on Armed Services. And he's concentrated on safeguarding the well-being of our nation's veterans and our men and women on active duty. We want to thank you for joining us today. We have received your written testimony, and the chair now recognizes our witness, Mr. Walter Jones.
Madam Chairman, thank you and the ranking member for the opportunity to bring this bill forward, and thank you for your understanding of the bill. You, as the ranking member, made very excellent comments about the intent of the bill, the content of the bill, and the importance. I would just like, in my brief time, to share my story and why I would get involved in a bill like this. In 1992, my father, Congressman Walter Jones Sr., died in office. He had announced he was not running for re-election, but he died in September that year before the November election. And he was under the old system. We have changed that system now, but he was under the old system where the proceeds in his campaign account could go as part of his estate. And his treasurer, a wonderful, fine gentleman, a lawyer, was an honorable man, but he said that based on the law, I cannot release these funds. And he was following the law, and we all understood that, but it got just complicated. And as you and the ranking member have said, in the time of death for a sitting member of Congress or a candidate for a congressional office, there's not a worse time for the family than to try to figure out how you go ahead and recover from the loss of the loved one. And it just seemed to me, working with my staff, my legislative director sitting behind me, Josh Bowling, that we decided a few years ago to put this bill in. Obviously, as you both have said, this is non-controversial. It is not partisan at all. I would call it a family relief consideration act when the member should die in office. We were able to work through the situation involving my father, but with the campaigns today and the cost of running for office, not me. If you check go on Open Secrets, you'll see I got about $100,000 in my account. So this is about my colleagues in the House, and as Mr. Brady said, hopefully we could get this through the Senate, and I know you feel that way, Madam Chairman. This is about thinking about pain and suffering and hurt should any of us die in office, or if we were candidates who had not been elected and we should be killed in a car accident or a plane crash or have a natural death. This is just to bring some peace and comfort to the family by allowing the candidate to designate, working with the Federal Elections Commission, whom he or she would like to disperse those funds, what charities, what churches, what campaign accounts or party accounts, and it's really, as you have explained in my little explanation, it is that simple.
Thank the gentleman very much. And you and I and Mr. Brady have talked about this on the House floor as well, and a number of different times. I really have to tell you the truth, and thinking about your bill, I hadn't really thought it all the way through, right? You think you're never going to die, right? You're thinking, oh, right, you're raising money and whatever you're doing, and what you would think if you did die, what kinds of charities that you do normally support that you'd like to see get X amount of the dollars, or the various candidates, et cetera. And yet, as you say, under the current law, the treasurers that we select, you could have a Republican treasurer giving money to a Democrat, or a Democrat giving money to a Republican, or who knows what, right? It depends, right? But, I've certainly, I think most of us hope that we have individuals that would carry out our wishes, but most of us really aren't really thinking about what our wishes actually are. I mean, it's not like drawing a will up, right?
Yes, ma'am.
But yet, in today's world, you talk about Open Secrets. You can go on Open Secrets. You see that I have in the $900,000, over $900,000 in my account right now. Well, that's some serious money, and there are some charities that I would want to get much of that money, and candidates and various things. But yet, you have to make sure that you have a treasurer, because it is up to the treasurer, not your campaign manager, or your spouse, or whoever, to determine where those dollars are going. And there are lots of candidates that have millions of dollars in their account. Again, we hope the unforeseen never happens, but who knows, right? And so I think it is just a very common sense type of thing to make sure that individuals who are donating to our respective campaigns, understanding what our values are and the kind of ideologies that we all have, our partisan persuasion, et cetera, that those funds will be distributed in a way that is consistent with what they were thinking when they were donating to our campaigns as well. So I'm very much in support of this bill, and I agree with Mr. Brady. And I know it has passed. I voted for it in the past, but in other Congresses, but it gets to the Senate and doesn't get very far. So hopefully we will be able to see that it actually becomes law. It is totally bipartisan. It is just something that I think needs to evolve as campaigns have evolved over the years, and the amount of monies that are left in campaign accounts are there as well. Well, how do you think the FEC would implement the bill if it became law? I know you've had some conversation with them in the past.
Yes, ma'am. Madam Chairman, they've actually testified during one of the hearings on this legislation, and they are in support. If this is the will of the Congress, they very much see the value of having this ability for the member to designate that family member, as you made reference to, whomever that person might be, and they would be able to fully disclose this on the internet. It would be part of the package of the candidate that files the paperwork to be a candidate, or the incumbent when he or she files their proper paperwork with the Federal Elections Commission.
Okay. Well, that was really my only question, and as you have already answered, it has to be publicly disclosed. Everything that we do, anytime you make any changes to any kind of campaign, the Campaign Act or campaign finance, et cetera, I think the operative phrase always has to be public disclosure, so that the public is fully aware of whatever is happening. And so to have that kind of public disclosure, I think, is absolutely critical and the appropriate thing to do. At this time, I have no other questions. Would ask the gentleman from Pennsylvania to ask his
Just briefly, as we sit here today as sitting Congress people, we can do, by law, follow the law and disperse whatever campaign funds we have to the way we want to, through our treasurer. If this bill passes, none of that changes. The regulations are exactly the same, and the filing is exactly the same as long as that account stays open. And the transparency is exactly the same. The only is that our treasurer now does not have the right to do that. Our designee, whoever we think that knows our wishes while we're not here, because it would be somebody naturally that would be closer to us than our treasurer would be, and they then have the task or the ability to be able to spend that money that we have left over under the same exact guidelines that we have sitting right here today. Is that correct?
Yes, sir.
Well, then again, like I say, this is a common sense protection bill that I thank you for bringing it forward.
It is that simple as just adding one line and allowing you to designate who would disperse your money should something happen to you. It's that simple.
Thank you. I appreciate it. Thank you. Thank you, Madam Chair.
Chair recognizes the gentleman from Mississippi.
Thank you, Congressman Jones, and I appreciate very much you bringing this bill forward, and we fully support it and look forward to its progress and ultimate passage, and I have no questions, Madam Chair.
Thank you, Mr. Harper. Thank you.
Chair recognizes the gentleman from California.
Thank you very much, Madam Chair. I also thank you for bringing it forward again. Appreciate all the work that you've put into it and fully support it. Thank you, sir.
Thank you, Mr. Honda. Thank you.
Thank you very much for coming. We
Thank
certainly
you for
appreciate it and appreciate your, as a ranking member has said, the persistence and tenacity with this, and we'll help move this along. We hope this committee will have a markup on the bill in the very, very near future and push it along to the floor as well.
Thank you so much. Thank you.
Thank you. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witness to respond as promptly as he can, so that those answers may be part of the record. And with that, the hearing is adjourned. Thank all the members and the witness.